Welcome to episode 6 of Ask an Attorney Anything. Today we're going to talk about, do you need a will or other estate planning documents? Before we get started, I want to give this one disclaimer. This video is purely for educational purposes and does not constitute legal advice from Stephen E. Wallace or the Wallace Law Group. So let's jump right into it, especially in light of all of the health-related issues and concerns and tragedies that many families are experiencing as a result of the COVID-19 pandemic. It's more important now than ever to have in place estate planning documents or review your existing estate planning documents. So, needless to say, if you don't have any estate planning documents in hand right now, the disposition of your assets will be governed by state statute. Each state is a little different, but needless to say, it generally goes to your lineal descendants, which would mean that if you have a spouse, it would go to your spouse. If you don't have a spouse, then it would go to your children, or it would go, if you don't have any children and your parents are still alive, it would go to your parents. It doesn't go lineally, which means that it wouldn't go to brothers or sisters. It could, after we go through the parents and the children and the spouses, then it could go to brothers or sisters and then aunts and uncles. But if you don't have any living relatives, all of your assets will escheat to the state, which means that the state will take over all of your assets. So it's more important now than ever to have a will, which in essence is a contract, which provides upon your death that all of your personal property or portions of your personal property will go as it's outlined in your will. Additionally, one of the things, ultimately, the complexity of your estate planning documents go to the amount of assets that you have, and additionally, it would go to, there's a variety of different tax planning and strategies that govern the necessity and the drafting of these certain documents. Additionally, there's other ways that you can structure your asset protection and your estate planning to avoid probate. One of the easiest ways is that you have a pour over will, and then you have a revocable trust, which basically is a great tool to avoid probate. Now, there are certain assets that pass outside of probate, meaning that if you didn't have a will, these assets would pass to the designated beneficiary. So, for example, life insurance is the most common asset that passes outside of probate. The only concern is that if you don't have a will and the beneficiary of your life insurance policy is dead, then there could be some complexities, and ultimately folks that you may not want to receive those life insurance proceeds could have the ability to access them. Additionally, if you properly designate your bank accounts at your bank, many bank accounts can travel outside of probate. Generally, the term of art is a survivorship bank account. And you would indicate at your bank when you open up the account that you want it to be joint tenants with right of survivorship. Or if you're married, you want a tenancy by the entirety account. Well, I hope you found this episode of Ask an Attorney Anything helpful. And the best thing to do is to contact an attorney, and we offer free consultations for us to review your estate planning documents or advise you if you don't have any estate planning documents. Stay well, stay safe, and I hope you'll subscribe to our channel above. And I will see you soon in our next episode of Ask an Attorney Anything.